All right, well, let's begin with our fourth panel of the day, a panel on a subject that's already come up a few times in earlier panels, nationwide injunctions. Now, as you could tell, our moderator for this panel is not Judge Ginsburg. He was very sorry to have to miss at the last moment. But it is my pleasure to introduce our moderator, our pinch hitter, Andrew Closter. It's a particular pleasure to introduce him because Andrew's first day on the job here as our deputy director is Monday. Andrew, we just hired to be a full part of our team and all the work we're doing here. We could not be happier for him to join us. And we could not be even happier for him to join us a day early and pinch hit for our missing moderator. That's the nice thing about having a deputy director now is I don't have to pinch hit for all of them. You don't need to hear me over and over again.
But he's just acting, right? Right today.
Yeah, that's right. That's the next panel. But no, just a brief word about Andrew. Andrew joins us from the U.S. Department of Transportation, where he served as legal advisor to the General Counsel in the Office of the Secretary. He clerked for Judge Mannion on the U.S. Court of Appeals for the Seventh Circuit. I got to know Andrew originally when he was a legal fellow at the Heritage Foundation's Center for Legal and Judicial Studies, where by happy coincidence he worked with one of our panelists, Todd Graziano, and I'm sure Andrew is looking forward to the opportunity to cut Todd off and tell him what questions to answer. So anyway, Andrew, thank you very much for joining us at the Center, and thank you very much for joining us today.
Well, thank you, Adam. Yeah, it's a real pleasure to be working here, and I look forward to helping the center advance the agenda of looking very closely at the administrative state. So today's topic is nationwide injunctions. I will introduce our panelists and very briefly. I know it'd be nice to leave lots of time for questions from the audience. The issue of nationwide injunctions has already been, as Adam mentioned, highlighted a bit in some of the earlier panels, so I won't give too much of a preview, but the question really is the scope of authority of the federal courts and when, if ever, is it appropriate for a court from the when is it ever appropriate for a federal court to be able to bar the federal government from enforcing a law against anyone, including potentially third parties. There are constitutional issues, there are administrative law issues here, and it seems like now almost every week, or at least every month, we're seeing some sort of case blocking a rule or action of the Trump administration, not just for the parties before the court, but also as against the entire world. So is this appropriate? When, if ever, is it appropriate? Is this even an appropriate description of the problem? That's what our extremely distinguished panelists will help us discuss today. So we will start with the Honorable Ronald A. Cass, the Dean Emeritus of the Boston University School of Law and currently president of Cass & Associates, PC. He has provided for us an excellent paper, which is online at the website. And so he will be speaking about his paper. So Dean Cass is formerly the vice chairman and a commissioner of the U.S. International Trade Commission, chairman and resident scholar at the Center for the Rule of Law. He sits as an arbitrator or mediator on a variety of commercial matters, and he is a member of the Council of the Administrative Conference of the United States. So he's truly someone who knows a great deal about this subject, both from inside the administration and inside various presidential administrations and as a lawyer in private practice. We will then proceed alphabetically. The next speaker will be Todd Graziano, as Adam mentioned, my former boss at the Heritage Foundation. Todd is currently the Pacific Legal Foundation's Chief of Legal Policy and Strategic Research here in Washington, D.C., and he's the director of its Center for the Separation of Powers. Prior to being at PLF, he was a long time at the Heritage Foundation. He was also sometime in the United States Department of Justice's Office of the Legal Counsel. So he has thought about constitutional issues quite deeply. And he also served as the Chief Subcommittee Counsel in the U.S. House of Representatives. And as a commissioner on the U.S. Commission on Civil Rights. We'll follow that up with the Honorable Scott Keller, who is currently a partner and the practice group chair of the Supreme Court and Constitutional Law Practice at the law firm of Baker Botts, LLP. He has argued 11 cases before the United States Supreme Court, including as the Solicitor General of the state of Texas. And he also previously served as Senator Ted Cruz's chief counsel. Finally, we have Professor Martin Lederman, who is a constitutional law professor at the Georgetown University Law Center. Formerly, he was the Deputy Assistant Attorney General in DOJ's Office of Legal Counsel during the in the first 2 years of the Obama administration, and he had served a prior stint at OLC from 1994 to 2002. He's a frequent commentator on constitutional issues and is also someone who's thought deeply about these matters. So without further ado, Mr. Cass, if you'd please talk to us about nationwide injunctions.
Well, I'm going to start with a story that comes to me from a friend of mine who's on the D.C. Circuit, who in his spare time likes to look over transcripts from trials. And he tells me this is actually true. There was a transcript he saw from a divorce case. And at one point, one of the lawyers asked a question of the witness on the stand. He said to her, is it true that on May 12th, 1997, in Rock Creek Park, at 6 p.m, you had sex in public with 4 members of the Hells Angels motorcycle gang? And there was apparently a pause, after which the witness said, could you give me that date again? Obviously, in life, there are some important issues. There are some trivial issues, and it's important to keep the trivial and the important separate from one another. What we're going to talk about right now are both some big points about nationwide injunctions and some smaller points. And I want to get some of the smaller points out of the way first. There is nothing that clearly makes nationwide injunctions, which are injunctions that are not limited either as to the parties covered or as to the geographic reach. There is nothing that clearly makes them beyond the power of courts to issue. There is nothing that says specifically you can't do that, nor is there anything that specifically says you can. There is a lot of background in the practice of the use of the equitable power to issue injunctions that says these are probably not what courts should be doing. They are extremely rare if you look back over history. They have become more common over the last several years under the Obama administration and particularly under the Trump administration, and have been used very often by political opponents of the administration to try to stop programs that the administration is putting in place that people on the other side do not like. I'm not going to argue that there are no occasions where these are appropriate injunctions. You heard earlier the discussion, Michael Grieva and David Rivkin were particularly clear on the issue of the use of certain types of rules to try to bind the real world, to try to put in place facts that will make it almost irrelevant what courts later say about what the law enables an agency to do. The mercury and air toxics rule, for example. I think, Dick, you may have talked about this as well as one of those examples. There are some cases like that where having an injunction that stays the operation of a rule is very important to preserving the opportunity to have an actual legal contest that means something over what the law allows an agency to do, how far it allows the agency to go, and then after that, you can talk about what the right remedy is to put in place. But the big points for me about nationwide injunctions are ones that cut almost entirely the other way. The big points are that if you look at the way the courts are organized, the way they are set up, it is clearly a setup that intends to have a group of courts with smaller jurisdictional mandates. You have to have, ever since 1789 and the first Judiciary Act, if you're going to be a district court judge in a federal district court, you have to live in the district. And the districts are composed in small geographic sizes. If you want to subpoena someone, you can only do it within a limited geographic range. If you want cases brought in that district, they have to be brought by people with the right sort of connections with contacts in the right sort of reason for being in that district. Then you have the circuits, which started out as trial courts for more important matters but evolved into intermediate appellate courts. The rules with respect to the circuits are that their decisions do not bind other circuits. District court decisions don't bind other district courts. And that allows the issues that come up in one district or in one circuit to come up in other districts and other circuits, and to come up with different fact patterns, to come up with different parties, to be argued differently to different judges, and maybe to get the same results or maybe to get different results. Maybe to be results that tailor an earlier rule so it fits the places where that rule is properly applied and not other places. But clearly, this set of authorities and rules is designed not to allow one district or one circuit to bind the entire nation. If there are conflicts among the circuits, the Supreme Court, if it chooses, can take a case that is an appropriate case that raises the issue that will resolve for the nation the right rule to apply in every circuit and every district. The federal government is particularly recognized as having permission to ignore a decision of a circuit outside that circuit if it thinks that the court is wrong and it wants to keep applying another rule, and let people challenge it in other circuits. Let people come before other courts and say that the first court that decided it was right and other courts should follow that. These are the systems we have in place that all keep the power of any one court to affect national policy modest. And if you run back the clock and look at what was being written in the late 1700s and early 1800s, Boyden Gray in his talk at lunch invoked de Tocqueville. De Tocqueville was very clear. So one of the great things about the way the American system is organized is that courts have power only insofar as they're deciding individual cases, only insofar as there's a concrete legal dispute among defined parties, and then they have power to say what the law is only so far as necessary to resolve that dispute. You have the same thing said by Hamilton in Federalist 78. You have the same thing said by John Marshall in Marbury against Madison. You have a lot of different people saying this in different contexts over time. Quite clearly, the courts were not designed to resolve big political issues. They were designed to apply the law. And if that means saying in the course of applying the law that an administrative agency has gotten something wrong, courts have power to say that. But usually that only has effect within one geographic region and only with respect to the parties in the case. So if a court decides that an agency is interpreting and applying the law incorrectly, it can say you can't apply that to this person who's here challenging it before us. But that doesn't mean that that court can bind the government with respect to all other applications of the law to all other persons. Sometimes, when a court has pronounced on an issue, if it's going to give any meaningful relief to the party before it, it has to do something that's going to end up having some spillover on other parties. When Texas came to the Supreme Court in the DACA case and said, look, we think that this program is inappropriate, it grants effectively permanent resident status to people who shouldn't be in this country. The Supreme Court said, appropriately, or excuse me, not the Supreme Court, the Fifth Circuit said appropriately, that if we're going to give any relief to Texas, we have to give relief that is broader than just Texas, because if you are in the country, if you can come in anywhere, if you can get permanent status anywhere, you can move to Texas because you have freedom of movement. So in order to do anything that protected Texas, they needed a bigger injunction there. But usually, in the ordinary case, that isn't necessary and it isn't appropriate. The problem, if you take nationwide injunctions as something that can become a matter of course, you incentivize aggressive forum shopping to find exactly the right judge or exactly the right court to do what you want, and then bind the entire country. That is a way of allowing political decisions to migrate from Congress and the executive branch, where they belong, to the courts where big political decisions do not belong. Questions of unchecked discretionary power in government are important questions. A lot of people who argue in favor of nationwide injunctions express a lot of concern that if you don't have them, you will have unchecked discretionary power, or not fully checked discretionary power in the executive branch, in the agencies. Those are valid concerns, but the right way to answer those concerns isn't to give broad, unchecked discretionary power to individual judges. The right way to answer those concerns is to use the constitutional mechanisms that were put in place to have Congress restrain the law or rewrite the law or supervise what is being done by the agencies, and to have the executive control what is being done, to let the political forces that are there represented by those two branches play out, and not to have people searching for one judge here or one judge there who can undo whatever is being put in place by the political branches. I look forward to the comments of the other panel members, and later we'll come up and deny everything I've said.
So before we move to Todd, I would just like to add one caveat for all of our panelists, which is that we're having folks here that are able to speak practically and about some of the issues involved with nationwide injunctions, but we aren't expecting some sort of unified field theory of nationwide injunctions from anybody here. So if folks in the audience have questions about how this all hangs together, that's of course appropriate, but we're really looking for practical advice here. So with that, Todd, would you please?
I'm going to provide my field theory in a few sentences, and it will be right, except that it will be indeterminate. But anyway, I'm delighted to join this panel on what is usually called nationwide injunctions. I'm going to take exception to that term because I don't think it's very descriptive, but I'm especially glad to provide some comments on Ron's excellent paper. Some of my comments are going to be based on Pacific Legal Foundations and my litigation experience. Now, the geographic denominator on nationwide injunctions is what I don't find helpful. Let's assume that I individually challenge a federal government watch list program that carelessly places me on it in district court in Virginia, and I bring a facial challenge. And if I win, I think there's no controversy that I'm entitled to an injunction against it being enforced against me nationwide. The harder question is whether the federal court finding my facial challenge to be justified should enjoin the program. And in some of Marty's writings and others, there are several types of injunctions that go beyond providing relief to plaintiffs. That's what the controversial issue is. And I think the most controversial of those are maybe programmatic ones. Can the district court? And so here is the answer to the question. These broader injunctions that provide relief to the non-parties, especially program, are generally not a good idea, except when they are, and they are whenever our clients need them. Now, putting that last joke aside, what I actually want to begin with where I think there is agreement. I think it was helpful for Ron to state that, particularly on this panel, I don't think any of us believe that equitable power providing relief beyond the actual plaintiffs is always constitutionally problematic. And even those scholars like Samuel Bray and John Harrison, who seem to have more categorical constitutional arguments against it, they have so many exceptions like class action and complete brevity and indivisibility exceptions that I think it swallows up their categorical claims about how bad or unconstitutional or problematic these are. So if we really do all agree on this panel and in respectable legal debate that they're sometimes justified and they're sometimes not appropriate, then we're just quibbling over how common they should be and in what circumstances. Now, I'm going to quibble with where I think some of Ron's emphasis is, and the exception that I think he acknowledges I think is more significant, and that's the APA regulatory context. But that may actually mask how much we really do agree on the principles. Well, to begin with, I think it is helpful to point out that the equitable power in Article 3 and even granted in the first Judiciary Act of 1789 clearly included some of the English courts, Chancery Court's power, which included the exercise of bills of relief and bills of bills of peace, I'm sorry. I knew I got that wrong. Bills of peace did sometimes provide relief beyond the parties who brought the Chancery claim to those who were similarly situated. But as I think Marty will explain in a little more detail, I actually, and I haven't studied this like he is, believe that the Article 3 and probably even the original Judiciary Act provided principles of conferred power, the principles of equity that go beyond the English Chancery Court's specific bills of peace example. But we can go further than that because I think Congress has also granted other authority to the courts that confirm equitable powers, declaratory judgments being the most important, and I'll turn to the APA example, which I think is perhaps the most significant, and the class action form, which does confirm that the federal courts do have various avenues to grant relief beyond the parties. But let me begin with one of the more classic examples of that. A federal court has the power, if it finds, to end all racially unconstitutional admissions policies across the board and not just admit Oliver Brown's daughter. And the court may have the power to do that for various reasons, one of which is that the student may have the right to actually be educated in an integrated school. But beyond that, the courts during the period of massive resistance determined pretty soon that they had to grant injunctions that were a little broader than to prevent the sort of massive resistance. So that's a stereotypical example, and I think not just quibbling. But let me mention another point of what I think is agreement before I depart from it. We at Pacific Legal Foundation often represent associations because individual members, sometimes when we're challenging government action, individuals don't like to be singled out for possible retribution. And the law is also, it's quite non-controversial that if we prevail against the government, we're easily entitled to an injunction nationwide for all of the members of an association. But there are some interesting cases, and one in a reported case that involves motorcycle club members in California, where it may be sometimes difficult for a court to grant relief to the millions of members. Let's say we represented the Farm Bureau, all the farmers across the country who are Farm Bureau members, but still allow enforcement of a particular rule against their neighbor farmers in the same districts. But now let me turn to the maybe most important example in my litigation experience, and that's the APA exception. The APA Section 706 actually instructs that courts, quote, shall hold unlawful and set aside agency action found to be, and then there's the four categories. One is arbitrary and capricious, another is unconstitutional, another is exceeding statutory authority, and the final one is, quote, without observance of procedure required by law. Well, there's a very interesting academic debate about whether that set-aside language requires programmatic injunctions in every case, and I'm agnostic on that. But I think it's inescapable that Congress authorized and expected, at least in some circumstances, that the courts, that a district court would set aside the action. And the procedural example is the easiest. Let's say one district court finds the notice and comment to be defective and requires notice and comment, and the agency would have a right of appeal. But it would be ridiculous for the agency that is undergoing notice and comment procedure to still enforce the invalid rule that they're redoing notice and comment on against everyone else. But I submit that result should also pertain in many other situations where where a rule is just struck down as illegal or unconstitutional. And our experience with the Waters of the United States litigation is a very interesting one. I won't go into detail now, but we can possibly talk about it in the question and answer period. But you've got 3 district courts for 28 states enjoining it, but not nationwide. You've got other association trying to get a nationwide injunction, but the court's resisting. And yet you've got 2 district courts who've struck down Trump's rule that delays implementation of that nationwide. And it's a terrible mess, and I submit that percolation, the need for percolation doesn't require that result. But now let me turn to, I think, my strongest critical or skeptical point with regard to Ron's paper and others who decry the danger of increased programmatic or other injunctions, and that is the inability of the appellate courts to police that. And here I'm going to suggest one reform, but I actually think they overstate the inability of appellate courts to cabin overly broad injunctions. So we all admit they're sometimes justified and they're sometimes not. I actually think the risk of not enjoining unlawful agency action programmatically is greater than the risk of over-enjoining it. And thank you, Dick, for mentioning the prime example, which is the Michigan versus EPA methane rule. There's a lot more of those kind of examples where, as a path dependency sort of issue, the agency doesn't care about losing a lot of district courts as long as opinions, as long as they can prevent it from going to the Supreme Court, and everyone's going to comply in the end. So I think the risk of under injunction, programmatic injunction, is greater than the risk that appellate courts won't overturn those that are improper. It isn't true that appellate courts have to decide the merits at an early stage. They can simply decide that the equities don't justify a programmatic injunction, don't justify enjoining people other than the plaintiffs. And my one reform recommendation is that I would like to see the courts of appeals have the power to stay or lift such injunctions that go beyond individual plaintiffs, not on an abuse of discretion basis, but on just a de novo that's similar to the what I understand to be the class action injunction review procedure. And I think there's a lot to be said for that. So I think that the main solution to the real concern that Cass and others have mentioned is that appellate courts police the scope of injunctions a little bit more. And I think that they are able to do it. Last point I want to mention is this elevating the value of percolation and the fear of forum shopping to a little greater extent than I think is merited, particularly when it's the federal government that's doing it. In our litigation experience, the federal government likes to have it both ways. They like to transfer any of the cases we file to their favored jurisdiction, and I'll give you an example, particularly where the law is more favorable to them or the judicial circuit is more favorable to them, and to prevent percolation. I think I'm over time, but I'll just mention that we filed 3 lawsuits, and over arguments of percolation, the federal government, where we pointed out the Supreme Court's precedents on legal issues, they succeeded in having those all transferred and consolidated to the D.C. District Court, but where we sometimes file in the D.C. District Court, they will transfer them to a court in the Ninth Circuit where the law is more favorable to them. So in my experience, the federal government hates forum shopping when it's done by plaintiffs. They want percolation when they lose, but they want the opposite result when it's to their advantage.
Thank you, Todd. Scott?
Well, and picking up on that, first of all, thank you very much for inviting me here today to speak with you. Obviously, in the state of Texas, we had a few of these cases that maybe have kicked off some of these debates. But I want to pick up on the point about the Department of Justice's litigating positions, because even framing this issue as an issue about nationwide injunctions, that in large part is a Department of Justice construct. And I think it is right to think about these. The issue is not just, is it nationwide, as Todd mentioned. Rather, it is truly more, is it programmatic? Can you give relief to someone else? And just as by way of example, take in the state of Texas. I mean, we had a series of laws passed by the state legislature that courts invalidated. Take our voter ID law. A district court in Corpus Christi invalidated our voter ID law, and we had appellate proceedings about it. No one really thought that we should have raised the argument, the injunction should only apply to the particular plaintiffs in that case, or should only apply to the city of Corpus Christi. It was a statewide injunction. So now, maybe we should have raised that argument. I don't know. But if you think about this, this isn't just about policies that are going to be these huge nationwide debates. And I understand why the issue is arising here. But this really does go to the equitable power, the injunctive powers that courts across the country in all sorts of cases are going to be able to issue. So those are the stakes. And it also, as far as how these arguments come up, and I know right now we're talking about nationwide injunctions in the context of blocking Trump administration policies. Of course, a few years ago, we were talking about them blocking Obama administration policies. And I think the issue really rose to some prominence in the Affordable Care Act litigation, NFIB versus Sebelius. So in some sense, it's trying to figure out what should the doctrine be, knowing full well that there will be future presidents and future executive branches of both parties. And so I'm glad we're able to have this dialogue today, and I'm not sure we're going to be able to come up with a master theory of this. I think it's easy to state what the master theory test should be, and then the application of it, though, is going to be very tough. And the theory is going to be what courts have said just traditional injunctive power should be, which is that you should tailor the injunction to provide complete relief to the plaintiff. Now, what is that going to mean in any given case? That's where I think courts are starting to struggle with how do you draw that line when you're talking about policies being set largely through the administrative state, the federal administrative state. And in some ways, I think, so the DAPA case that we litigated in Texas, I think in some ways it's unfortunate that that was a prominent example of nationwide injunction that is now being held out as, oh, of course courts have this power to issue nationwide injunctions. Because I think, as you've heard from Ron and Todd, the DAPA case, to grant complete relief when you had a 26-state plaintiff coalition talking about was someone lawfully present in the country, that necessarily has to apply nationwide. The nub of the claim was, is someone lawfully or unlawfully in the country? You couldn't say that, well, they're lawfully in California but not lawfully in Texas. And there are all sorts of reasons why immigration, I think, is a unique context. And that's what the Fifth Circuit said in affirming the nationwide injunction there. Another issue that I'd point out too is I think this is all unfortunately coming up in a unique context in that there were a series of lawsuits challenging Obama-era policies that the Trump administration has attempted to rescind, but then there's been collateral litigation blocking the Trump administration's rescission of the Obama-era rules. Now, why do I say that's unique? I don't think we've really ever seen that much litigation over blocking the agencies changing a position from a prior administration. But what I think that did is it stifled the ability of the Supreme Court to take some of these challenges directly to the Obama-era rules. DAPA, EPA Clean Power, and a few other cases, DOL Persuader Rule, although, the Persuader Rule litigation is, so I could go down the list of, the alphabet soup of federal agencies and policies that have been shifted. But I think all that matters because normally the Supreme Court would be in a position to take some of these cases, and I think that has delayed the ability to do that. Because as a practical matter, and this gets back to Todd's point about, is percolation worth it? Maybe having different judges with different viewpoints is going to help the Supreme Court in some of these tough cases. At the same time, the Supreme Court is very sensitive to knowing that if a federal law or federal administrative program is invalidated, that is an issue of exceptional importance to the nation, that the Supreme Court is going to be very attuned to taking. And so in some sense, this is really about, and I think the Supreme Court does need to clarify, when is the Supreme Court going to be stepping in on the front end to do this? And I think some of the frustration from the current Department of Justice in trying to get some of these cases up there to get more clarity on this stems from that. At the same time, the Supreme Court, and rightfully so, is going to want to be sure that there are all of the viewpoints and arguments that are aired before it actually does so. And in that sense, the issue about programmatic injunctions in some ways tracks a little bit of the confusion the Supreme Court's had on the issue of facial challenges. So in the 80s, the court, an opinion called Salerno, said that if you could show that there is no set of circumstances in which a law is valid, then it is facially invalid. Now, the court didn't tack on to that sentence or that test, ... therefore you can strike that entire law. But that's essentially what that has come to mean. Well, if you think about it, if a law can be shown to be valid in no set of circumstances, and then you go to what should the remedy be, well, if the court is saying there's no set of circumstances is valid, then why wouldn't a court, as a matter of course, just enter an injunction saying, well, the law's always invalid? Of course, that means you're going to have a programmatic or nationwide injunction. So in some ways, the fact that the court has distinguished between facial and as-applied challenges is another aspect of this that has led to this current state of affairs where what do you do when the legal reasoning that the court engages in would actually find this to be invalid in all circumstances? And then you throw on and tack on the language that Todd mentioned in the APA, the set-aside language. I mean, that is a directive by Congress to take some remedial action regarding an unlawful agency action. Set aside sounds a lot like vacate. Sounds, I suppose you could set aside for the particular parties, although that would be a really odd way to phrase that. Of course, that means that every time you have a federal agency acting unlawfully, that then you're supposed to issue a nationwide injunction? I mean, that doesn't seem quite right either. So in the end, as I said, I think there's going to be a very easy way to phrase what the test should be, and that's the traditional injunctive equitable test. But the devil is going to be in the details. And as the former Solicitor General of Texas, we were attuned to this issue in the sense that we were not asking for nationwide injunctions every time we were challenging a policy that even would have resulted in a successful facial challenge. We did ask for a nationwide injunction in the DAPA litigation. I do remember distinctly another case we were challenging the Title IX, some of the transgender issue rules. And there we specifically did not ask for a nationwide injunction. I mean, sometimes as a litigant, I mean, this issue has become such a hot button issue that you almost don't want to touch it because you have to ask, how much does your client need that relief? I know right now in the city of Chicago, Sanctuary City federal funding case, that has become somewhat of a flashpoint in that the courts up there said it was unlawful for DOJ to condition federal funding on not being a sanctuary city. And then the court issued a nationwide injunction. The Seventh Circuit initially upheld it, although that's now under review, upheld the nationwide injunction. And so in some situations, I think it's going to depend, how much does the actual plaintiff, the litigant, need the relief, or how much is a plaintiff trying to throw a wrench in the political policy preferences of an opposing presidential administration. And I think some of this will continue to play out, but obviously until we have more guidance from the Supreme Court, I think this is, for better or for worse, going to be a quiver or an arrow in the quiver for various parties that are coming to court from opposing political viewpoints. So I'm happy to answer all sorts of questions in Q&A, and I'm going to turn it over to Marty now, so we have plenty of time for
Great.
that.
Well, thanks very much. Confession here, I'm somewhat of an interloper or a squatter from the next panel. I'm invited in to try to, I suppose, bring some diversity to this panel, but I'm afraid that there's perhaps less diversity on a lot of different metrics than we had hoped. We agree on a lot of things up here substantively, I believe, but I'm going to try my best to at least probe at what might be some differences, at least on Dean Cass's paper and his suggestion that this is a bad idea, even if lawful. And I want to press a little bit, as Todd did, on why that might not be true or when it might be true. So let me just give a little bit of the background on the legal questions, because this really is an issue that is right now sweeping like wildfire in the Academy and in Congress as to the legal authority of district court judges to issue what we've been calling nationwide injunctions, but are better described as universal injunctions. Injunctions against a state, a government, state or in this case, federal government, that extend to non-parties, to persons not before the court, right? Prevent the government from acting with respect to not just the people in court, not just the plaintiffs, but others as well. Sometimes that's, there's actually a whole slew of famous and not so famous cases. Happens every day that courts issue injunctions against governments not to treat party X in a particular way because it will harm party Y, and it's party Y that's in the court. That's actually quite common. And so, but these injunctions extend to everyone, right? So they say to the government, you can't apply this policy to anyone, and you're enjoined from doing so. So let me just give you a little bit of background, since we haven't really covered it, about what the legal questions are, and then I'll get to the legal policy questions that Dean Cass has teed up. There are two principal legal arguments. The first is a constitutional argument, and Professor Bray and others have written quite interestingly about this, and that's the idea that under the court's modern standing doctrine, with which I take some issue, there's an idea that a plaintiff only has Article III standing to seek remedies that will actually prevent injuries, in fact, that they will be suffering if the defendant is allowed to act as the defendant, the state here, wishes to act. And so seeking a remedy that the state stop enforcing its law against non-parties with whom the plaintiffs have no relationship at all, there's an argument the plaintiffs simply don't have standing to seek that kind of remedy. It's an Article III argument. And it's easy to read a lot of the rhetoric in the modern court's Article III cases to support that view, but there's just too many counterexamples of the court itself allowing courts to act, to provide remedies to non-parties that would call that into question. Most importantly, perhaps, the Supreme Court's own first decision in the travel ban case last summer in Trump versus IRAP. The court cut back on the nationwide injunctions somewhat, but still extended them to plenty of people, prohibited the Obama administration from keeping out of the country plenty of people who had no relationship to the plaintiffs in the case, to Hawaii or to the individuals in the case. So the United States Supreme Court, confronted with this issue, it was briefed to the court that plaintiffs did not have standing to seek that kind of argument, to seek that kind of relief. Grant allowed it anyway. In fact, the court crafted the injunction of its choice thereby, I think, undermining, rightly in my view, the Article 3 argument. The stronger argument, the more interesting argument, is that district courts don't have the statutory authority to issue such injunctions. And the basis of this argument is that they have the authority, the statutory authority they invoke is in the Judiciary Act of 1789, gives all district courts in the United States the power in certain cases, obviously, under Article 3, all suits in equity that satisfy Article 3 otherwise. So the question is, what is a suit in equity? These are equitable lawsuits being brought. Is this the sort of relief that comes under that broad heading of equity, suits in equity? And the Supreme Court justices have been split in recent years as to how broad that category ought to be. How closely tethered to the old forms of relief that were understood the Chancellor was allowed to give in the British system before the Constitution does a remedy have to be in order for it to be within Congress's authority to give the courts the power to issue equitable relief? What does equity mean? Well, equity to me seems like a fairly broad concept, one that the whole point of equity is to be flexible, to be to evolve over time as people's understandings of what is fair change over time, and that Congress would have wanted the courts to have this kind of power. And there's a lot of interesting academic literature right now about how closely these sorts of injunctions do or do not correspond to the sorts of relief being given in the 18th century, all of which is very interesting, but I think ought to be somewhat beside the point. But there is an interesting question then of statutory equitable jurisdiction. Assume there is equitable jurisdiction, which I think the Supreme Court also assumed when it crafted the injunction in the travel ban case. Then we get to the question, okay, ought they give these sorts of injunctions? And that's where Dean Cass says no, right? Or at the very least, they should be cut back. We should be wary of district court judges willy-nilly granting these forms of injunctions to protect, to categorically preclude the national government, in particular, or even Scott's client, Texas, in the cases that he mentions. Right? Why should one person in Corpus Christi be able to get an injunction that bans the state of Texas from applying its law to everyone in the state of Texas? It seems a little odd, and as a former government lawyer, I used to be very steadfast on this idea that courts ought to only grant relief to the minimum extent necessary to give full relief to the parties in the case and no further, and I still have that instinct. But the more I think about it, I'm not sure that the harms that Dean Cass identifies are really all that pronounced, first of all. And secondly, I want to situate this question now. The reason it's coming up now is because we've had a series of cases. I don't have to tell this audience, you're all familiar with the fact that an extraordinarily interesting phenomenon of the last 10 to 20 years, and everybody will trace it back to a different point. Mass versus EPA might be one, but certainly it accelerated dramatically in the Obama administration, thanks in no small measure to Scott and his client, but others as well, of state officials suing the national executive branch for relief whenever the opposite political party either has the gubernatorial or the attorney general's office in those states. It's happening now in Democratic states. It happened in Republican states in the Obama administration. To my mind, this is a really fascinating federalism sort of issue and development. And it's happening more and more. And yes, these parties are running into a district court that they hope will be sympathetic to them. In particular, in a lot of courts, you don't know which judge is going to be assigned, so it's a crapshoot anyway. But in some courts, there's very few judges, and you know that your odds are pretty good. Of course, that's happening, and they're granting nationwide relief. Most of these cases, the modern ones that everyone's concerned about, DAPA, and just an aside on the DAPA litigation, I actually agree with Dean Cass and with Scott that if Texas had standing, it probably was necessary to issue a nationwide injunction. Texas's theory of standing was it was going to harm them to have to give driver's licenses to DAPA aliens who resided in Texas. Well, Scott's right, and Dean Cass is right. You know, an alien in Maine might move to Texas one day, and so you need to keep them out of the country in order to prevent that possible harm. My biggest problem with that case, which I've written extensively about, is that I don't think Texas had Article III standing in that case at all. They weren't being injured by TAPA in the slightest. But once you can see that they do, a nationwide injunction made sense. But there were a lot of cases in the Obama administration. As an Obama administration lawyer, I was upset about the nationwide injunctions being issued. I'm even wary about the ones being issued now, challenging Trump administration policies. But let's think about what's going on here. Generally speaking, not categorically, but generally speaking, an administration issues a policy, and it promulgates a policy of great controversy and of great legal controversy, great legal contestation about whether it's lawful. These are not, I take issue with Dean Cass on this, these are not just big political issues. Every one of these cases, including DAPA, where I disagreed with Scott, but it was a serious legal question. Does the president have this authority? It's going to be resolved by the Supreme Court, and it's going to be resolved by the Supreme Court probably within a term, but 2 at the most. All of these cases that we're talking about, sanctuary cities and transgender and transgender in the military and DAPA and DACA and ACA, they're all going to get to the Supreme Court. And the Supreme Court's going to issue a merits decision, more likely than not, in each of these cases. And when it does, the Supreme Court's decision, even absent an injunction, is going to be treated as a nationwide universal injunction. The federal executive branch, whenever any of these laws is declared invalid by the Supreme Court, is not going to continue to implement them or execute them with respect to non-parties. It's going to abide by the Supreme Court's judgment, and as Todd points out, the federal government regularly abides by the rulings of the D.C. Circuit when they declare a regulation or a rule invalid under this language of the APA that they can set aside a rule. Professor Bray says that actually was designed for adjudications of individual parties, but whatever, the federal government's just not going to say to the D.C. Circuit, fine, as to that party, we won't apply it. They're going to stop doing it. They're going to go back and do notice and comment or amend it or take a petition to the Supreme Court. So what the controversy here is all about is what the status quo should be. Should the rule be able to be applied in the few months or maybe year and a half before the Supreme Court rules on this case? Now, once you get an injunction, that means the default is, if it's a nationwide injunction, is it won't be applied. But I think Todd's right. The courts of appeals, and in particular the Supreme Court, which has gotten to be much more aggressive about its superintendence of these questions, if the Supreme Court suspects that it will ultimately uphold a federal government rule, it will approve or issue stays of these injunctions so that in the interim months or year and a half, the injunctions will not have effect. And if a majority of the justices think that it's likely we will agree that it's invalid, then they'll let the injunction stay. So is this a bad thing? Is it a bad thing if in a case where it's likely, or at least possible, the Supreme Court will eventually declare a law unconstitutional, a regulation unconstitutional, that in the meantime, everyone in America benefits from an injunction that a particular plaintiff was able to obtain? And I guess I've been changing my view to think, yeah, that is a good thing. Professor Bray gives the counterexample. During the New Deal, the case he gives is between 1935 and 1937, the courts had not been in the practice of granting these global injunctions then. There were 1,600 injunctions issued against implementation of the processing tax of the Agricultural Adjustment Act. 1,600 separate plaintiffs got injunctions, and a bunch of others didn't because other district courts didn't agree. So the government applied this tax to half the nation, but not to 1,600 people during the time it was percolating up to the Supreme Court. I don't think that's a great state of affairs. I think, generally speaking, it makes sense for everyone either to be subject to the injunction or not, as the Supreme Court and the courts of appeals think fit. So just very quickly on Professor Cass's concerns, the two main ones are forum shopping and percolation. I don't think percolation is a problem. As we're seeing in every single one of these issues now, notwithstanding these injunctions, many, many lower courts are opining and giving all sorts of varied and diverse views on the legality of these of these rules. That hasn't been an issue. And as for form shopping, yeah, maybe there's a little bit too much of it, but quite frankly, even if these injunctions weren't in place, these sophisticated plaintiff lawyers would still be looking for the most sympathetic judges they could, even to bring a case in which they're only going to get a ruling as to 1 or 25 or 100 parties rather than 300 million. So my final question for Dean Cass is, since you don't think there's a legal objection, what I was waiting for in the paper and what I'm curious about is, it seems to be that your paper is leading up to a proposal that you're urging Congress to issue, to write some sort of statute to limit this practice. And I think there actually is a statute pending and that's gotten out of one of the committees in the House, but I think it's very flawed. It's very hard to write that kind of statute, to describe the cases that you think ought not to be subject to nationwide injunctions and those that might be. And so I think the challenge, even if you agree with Dean Cass, is, well, how would you write a law that would actually cabin the district courts in a way that people would be more or less comfortable with?
All right, thank you very much. So, Dean Cass, if there's anything you'd like to respond to, please take a moment.
There are a few points I'd like to do. I appreciate all the comments, which are all quite thoughtful, and I think it's fair to say that while we do disagree among ourselves on some points, the disagreement is fairly cabin. Let me just make a few points quickly. First, on the Section 706 point. Section 706 is not a provision in the APA that is limited to application to rules. In fact, it applies to any agency action, and that's why, in addition to the items, I think, Todd, you read out the number of different items. It says if any of these happen, you set it aside. It also goes on to say, if there isn't substantial evidence, if that's required and there's the decision is subject to review de novo, and these are dealing with adjudications. And it also says that if it's unwarranted by the facts, if it's not, there isn't substantial evidence, unwarranted by the fact, those are two separate categories for setting unlawful and holding something aside. That only makes sense if you're setting aside an individual decision with respect to what is coming before you. And so, and if you turn back the clock and you look at what this meant at the time the APA was written, we didn't have a lot of different rules adopted by agencies, and we didn't have a lot of things being set aside globally at all. In fact, Marty was just talking about what Sam Bray had said about what was going on during the New Deal. In fact, what people thought at the time this language meant was that something would be set aside with respect to the people in the court. It would not apply to them. If you look back at Marbury and Madison and what is going on there, if you look at almost all the litigation leading up to, and I don't know where to start this, whether we go back 5 or 10 or 20, however many years, but the nationwide or national or universal injunction is a fairly new thing. Cases where this tended to be applied in earlier eras were cases where there was something like a challenge to a rate making, and the same rate had to be by law applied to everyone. So a lot of common carrier litigation is where you see something like this. But by and large, it was an extraordinary thing that happened only in special cases where there was a special reason for it. With respect to the DC Circuit, and I've talked about this with a lot of my friends on the circuit, the DC Circuit has exclusive jurisdiction over appeals in about 130 laws. If you have exclusive jurisdiction and you say don't do something, the people can't do something. And this isn't something where we're going to have it taken to other courts because no other court has jurisdiction over it. So it's a one-shot deal there, and if that's how you're used to thinking about a lot of administrative law issues, of course we think of it in terms of setting it aside globally. Plus, if you are the court in D.C., and you're talking to government officials who are located in D.C., of course you have jurisdiction to tell them, don't do this with respect to anybody. But those aside, it really is extraordinary to have injunctions that sweep this broadly. And remember that injunctions are different than other forms of equitable relief. If there is a declaratory judgment where the court sitting in Seattle says, this is what the law means and it is not constitutional for you to do what you're doing, and the government goes ahead and does it anyway, what's the penalty for the government officials doing it? They may be told by another court, don't do it here either. With respect to an injunction, you can be held in contempt. And the fact that what you were doing you thought there was a good reason for and somebody else thinks there's a good reason for isn't a defense to that suit. And there's a line of cases that say even if ultimately it's concluded that the decision of the court issuing the injunction was wrong, that doesn't protect you against a penalty for violating the injunction. So there's a real problem here with respect to these sorts of injunctions. It's a practical problem. And it's not a problem that exists the same way in state courts with respect to people in the state. It exists if you have a court in one part of the U.S. binding the entire country. When we talk about the operation of the courts and you go back and you look at the design of the federal judiciary, the reason why you have to be a resident in the district to be a judge in that district is because we thought people would actually have different views in different parts of the country. We thought they might respond differently to different sort of positions that people had about the national government. When you have a routine where the minute the federal government does something, 15 or 20 attorneys general of the other party come in and agree to file suit in the jurisdiction most likely to have a favorable outcome, you are really changing the dynamic of political decision-making in the country. And yes, you may have the Supreme Court, when that's happening, jump in sooner as a result. And you may have the Supreme Court feel like it now has to review earlier on a lot of these injunctions and decide whether to leave them in place or not. And yes, at the end of the day, there may be a lot of things that kind of move around to compensate for the distortion of the system. But I don't think that justifies the distortion. And then one last thing, and I'll turn this back to everybody else. Marty's question, which is unfortunately a very good question, about if you don't think these are categorically outside the scope of what is lawful, how do you write the rules about where they can and can't do it? I think that's a serious question. And I have some recommendations on what the law should look like. But I think you have to leave scope for the appropriate case. And again, I think the mercury and air toxic rule, there should have been a stay of the rule, because otherwise you have no meaningful review. I think there are other examples that are like that. And there are cases, and I think, again, putting aside, I'm not talking about the standing issue here, but putting aside the question of whether the case is properly in the court, was that an appropriate case? Yes, I think it was. But you have other cases, like the Fourth Circuit says, well, you need to actually give the plaintiffs the relief that is condemning this rule. If you think it's wrong, you should condemn it nationwide and not let it stay on the books. And that's something different than the framers of the APA had in mind. It's something different than courts used to do. It's something different than was envisioned when we created the system of separate courts that we have today. And I think it is inappropriate and does make a fundamental change in how the law operates. And that is what Nino Scalia was very much someone who believed in the rule of law. He was very concerned about the rule of law. He was very much someone who didn't like handing over large amounts of discretionary authority to anybody. Although if Congress wrote the law appropriately and handed out discretionary authority to some administrator, he would say, fine, the administrator is free to exercise discretion up into the limits of what the law allows. But that doesn't mean that he wanted to have individual judges have the power to say for the nation, acting in their own discretion, what that would be.
All right, thank you very much. Before we go to the audience, we only have, it seems like, about 15 minutes, so I'd like to get through as many questions as possible. So if we have any questions from the audience, I guess I'll ask the first one while we're waiting, which is, if you could briefly, since we're talking practically, Class actions, do you think the class action form, Rule 23, is appropriate in this context? It has a lot of prophylactics that are not available right now in the nationwide injunction context in terms of immediate appealability and opt-outs and, strong review of, the scope of the relief at the front end rather than at the back end. So, I mean, is that something that makes sense to kind of help limit some of the major problems that these might otherwise show?
Well, I mean, first of all, as Marty mentioned, I actually think one of the reasons why you've had this explosion of litigation is because it has in large part been driven by the states. And I think that's actually a collateral consequence of many states getting solicitors general. And when you have high-level, top-notch appellate talent going into AG's offices and AG's offices prioritizing that, that's going to lead to some of these battles where, I mean, California just recently created a state SG office, and we were very proud to hear they were marketing themselves saying, come work for us, we want to become the next Texas as far as an SG's office goes. Now, I raise all that just to say that I have a feeling that California is not going to want to be a part of a Texas class action, and Texas isn't going to want to be a part of a California class action.
One day.
Yeah, maybe. We keep hearing about that. But that's to say that at least if this continues to be state-driven litigation in large part, I don't think the class action mechanism is going to work. Of course, there are many other litigants in these cases besides states.
I admitted to Andrew before the break that I didn't know a lot about class action, but what I do know, I think, cuts both ways on this question. I think it does. The more interesting question is in creating different class action rules, did Congress mean to cabin representational litigation to class action? What little I know is that Congress did not intend to do that, including because at least there are different types of class action, but class action provides damages. So I don't think that they meant to do so, but it does make me skeptical, the existence, the cabining of some at least representational injunctions makes me skeptical of the virtue of judges providing relief beyond named plaintiffs where it isn't a class action, except in all those other cases that I've mentioned where it is appropriate. And there are, I think Neil Katyal in a recent FedSoc debate used a good example of the original travel ban lawsuit was a very chaotic situation. Class action just would not have been possible for all the thousands of people trying to fly in. And you had the original judge in Massachusetts strike down the original travel ban. And I think we would admit that there was no notice, that there were more problems with that one. So assuming that is right, that judge only did not make it nationwide, despite the fact that the Constitution has this other virtue of wanting uniform rules of immigration. And as a result, then you had thousands of foreigners. So the travel ban didn't apply at Logan Airport, and you had thousands of travelers chaotically trying to travel into Logan Airport. That was an example where class action would not have worked. And I think a uniform rule setting aside, if an individual judge thought that the travel ban was unlawful, as the original judge ruled, he should have made it, or she, I'm not sure, the judge should have made it nationwide and just left the appellate court to determine whether the equities really were as the individual judge saw the equities. I think the default rule in that situation should have been global, galactic, intergalactic, or whatever.
So the talk that Todd just mentioned, and please, if there are questions, raise your hand and the mic will come to you. The talk that Todd just mentioned was a Federal Society debate between Professor John Harrison, who I thought knocked it out of the park, and I think it's online, and Neil Katyal, who's an appellate practitioner.
Did Neil not knock it out of the park?
I think he knocked it around.
Dueling home runs. So.
Please.
Hi, my name is Matt Cannon with Public Citizen. Thanks for the panel today, really interesting. I wanted to circle back to legislative solutions. So there's at least one proposal in Congress that would prevent nationwide injunctions at the district court level but allow them on the circuit court level. Is that something, I'm curious your thoughts on that. I suppose the question would be directed at Dean Cass, but curious everybody's thoughts.
I think certainly if you have a limitation that takes it out of the hands of an individual judge, that's a step in the right direction. But I think what you need first and foremost is some basis for there being a need for the injunction to apply to everybody, not just the parties in the court, and everywhere, not just locally. One of the questions that Todd had asked earlier is, wouldn't it be ridiculous to have a judge say that the failure is not having notice and comment before crafting a rule, and therefore the rule shouldn't be applied anywhere to anyone? You could imagine the government thinking that this is not a rule that needed notice and comment, and so it continued to apply the rule to everyone, everywhere, except for the party to the suit or parties located in that district. Obviously, when you bump it up to a circuit, you have a bigger jurisdiction. But clearly, a lot of times we've had circuits differ in their reading of the law. We've had a period of time where different circuits have had different readings of the law. Sometimes that looks to be something that is a simple disagreement in what the law means. In the cases we're talking about, one of the problems I have is that increasingly the courts being sought out are those that have a strong inclination toward one viewpoint that is strongly associated with one political party and is being sought out because people who are of that political party oppose something being done by somebody in the other political party. And the more that is true, the more you're seeking out the tails of the distribution of the courts and the judges, and you're doing it on grounds that look to be very closely allied with politics. It doesn't mean there is no legitimate legal issue. And it doesn't mean there is no legitimate basis for resolving that issue either way. But it does begin to look like you are politicizing the judiciary in a way that I think will redound to the harm of the judiciary in the long term, and I think is not what was intended when we set up the system of courts that we have.
I'll just say very briefly on the legislation that even if you are a proponent, Dean Cassie is, of trying to limit so-called nationwide or global or universal injunctions that apply to parties with no relationship to the plaintiffs. This is very blunderbuss legislation that I'm happy to say now will not go anywhere. It provides that no federal court shall issue an order that purports to restrain the enforcement against a non-party of any statute, reg, order, or similar authority unless the non-party is represented by the party pursuant to the class action rules. That would be a radical transformation of American law, because when you really start thinking about it, in most famous cases, or many famous cases, in many cases we will all approve of the scope of the injunction. Courts issue injunctions against the government, preventing them from applying laws or regulations to parties not before the court in order to give full remedy to the parties before the court. It actually is far more frequent than we think because it's become so common to us. And so that legislation, if it were to go anywhere, would at the very least, I think, have to have a carve-out for, except as necessary to provide full remedy to the plaintiffs.
Let me just, Ron, just what would be ridiculous is if the district court struck down a rule for violating notice and comment, the circuit court affirmed, DC Circuit denied cert, and so the agency is going to have to actually do notice and comment, but under, let's say, some race theory, the federal government doesn't need to acquiesce. It's not the DC Circuit. You would agree, I think, in that situation, that it would be ridiculous to not apply a nationwide injunction while the notice and comment?
Well, pretty much every case we have that's like that is a case of exclusive jurisdiction of the DC Circuit. So it really is the case where if the DC Circuit is the only court you're talking about, you don't have to really worry about that.
I'm surprised to hear such a pragmatic tendency on the panel, and I wonder what your response is to what Bray says. I don't know the history, but he says that the first such universal injunctions really crop up in the 70s. And so that history, if it's true, seems very problematic to the idea that we kind of need this in order for the system to work. So what's your response to the history of this?
I will just say I think that history is right. There are things that are similar to like a stay of an agency rule happened before that point, and that is, in effect, a temporary injunction. We call it a stay, but it is a temporary injunction. But it happened in particular cases with particular reasons for it and grounded in law, although oftentimes when these were happening in the 70s and 80s, they weren't being talked about very critically in terms of where the authority comes from.
I don't know the history well, but I think one issue is the way he defines things, and then he can define it so that the first one is the class action is itself a representational litigation, which in some ways he creates an exception to.
Well, Congress creates the exception. I mean, that suggests that we don't need a default rule that allows these universal injunctions if Congress has mechanisms for creating alternatives.
What do you call some of the injunctions in the 50s and 60s in response to massive resistance that ordered desegregation rather than just granting admission to individual plaintiffs? I think they were
nationwide.
They were not nationwide.
True, but they went beyond the named plaintiffs, is what I'm saying. The issue to me, I don't like the geographic name nationwide. The principle, as I understand it, that's being criticized, and I'm normally sympathetic to, is the judge going beyond, granting relief beyond what the right of the individual plaintiff.
So I think this is fair, and if Bray's account is right, for instance, it's interesting that during the New Deal, 1,700 or more cases were being brought against each of these statutory provisions that were being challenged, and no one thought to ask for relief that was nationwide, apparently. And I think that probably reflected what judges and lawyers thought was the extent of the power of equity of Article III courts at the time. Now, Bray has been, there are others who are writing, I don't know who's right or not. It's all analogical in terms of finding even deeper historical sorts of relief that was issued in England and in the early and in the colonies and the like, to describe what the extent of equity is or ought to be. And you might think, boy, this is just too far a stretch from what the equity courts were doing before the Republic was founded, that you should at least, maybe the default rule should be you can't do it until Congress comes up with a plan to allow it. I don't know. I mean, I think the courts over time, and the Supreme Court in particular, have been appropriately flexible about equity, right? And the Supreme Court itself, in, for instance, the travel ban case, but many others, said that equity requires the courts to consider the overall public interest in crafting injunctions. Oftentimes, they give less than complete relief because the public might be harmed by it. Similarly here, it seems to me the public, if it's a case where the Supreme Court itself is not going to grant a stay, it's better that everyone in the nation during that 6 to 18 months be treated the same rather than 1,700 people being treated differently.
Just two quick things, because I think we're at the end of our time period. First, with respect to Todd's point on the integration cases, the claim wasn't just a personal exclusion, it was also being forced to attend a school where there was a segregated student body. So in order to give relief to the people in the court, to the parties in the court on a claim they were making, you couldn't just say, okay, you can get in, but no one else. So this is very much like the case that we were talking about, the claim Texas was making in the DAPA case. Second, with respect to Adam's broader point and Marty's rejoinder here, I think the serious question is, what is the default rule? What should the default rule be? Should you have a presumption that you can't do this unless you're specifically authorized to do it? That makes perfect sense if you're talking about something that nobody thought you could do until relatively recently. And as someone who generally has a bias against modernity, that would suit me just fine.
Well, join me in giving a hand for our panelists and the future Universal District Court of the United States.